you do?
Yes, my name is Migele. I'm an advocate of the High Court of Kenya, practicing majorly in Nairobi, but also practicing handling disputes and cases outside the jurisdiction of Nairobi. But my postal address and physical address of work is here in Nairobi. So I'm a Nairobi branch member, but generally an advocate who can provide legal services across the country.
Okay.
Yes.
Now we begin with what you saw yesterday during the impeachment of Governor Nyaribo. What were your takeaways from?
I think that under the Constitution, Article 181 of the Constitution of Kenya, it empowers the members of County Assembly and the members of the Senate. It empowers them to impeach a governor. The process originates from the County Assembly, and the procedure is majorly governed by Section 33 of the County Government Act. So that process requires that it is governed under Section 33 of the County Government Act and also the individual County Assembly standing orders.
Yeah.
So the procedure under Section 33 of the County Government Act requires that the members of the County Assembly, at least a third of them, can sign and support a motion, initiate a motion for the removal of a governor.
Yeah.
The grounds of removal of a governor are set out under Article 181 of the Constitution.
Yes.
Gross misconduct, gross violation of the Constitution, gross violation of national or international law. Majorly, you'll find that the substantive test will be around those provisions.
Yes.
So once a third of the members of County Assembly initiate a motion for the removal of a governor,
Yes.
then they have to get the support now on the floor of the County Assembly of at least 2/3 of the members of the County Assembly. Now, it is up to the members of the County Assembly to make sure that at the time of initiating the removal of the governor at the County Assembly, they comply with their respective County Assembly standing orders. The standing orders, that's like the National Assembly, the National Assembly and the Senate have their standing orders. The County Assembly also need to comply with their orders, so that in terms of procedure, they don't fall the trap of failing the preliminary test of whether they complied with the procedure.
Yes.
If you look at the 3 removal of governors process that have happened before, you realize that the decision or the vote that was passed to remove the governor does not get to substantive hearing at the Senate. This is simply because the members of the County Assembly do not invest in compliance with their procedures under the County Assembly Act, the County Assembly standing orders, and their respective under Section 33 of the County Government Act. So my first take home is that each county assembly in the Republic of Kenya need to invest within the assembly. Because I know the county assembly has a budget. I would advise all the county assemblies to invest on legal professionals who constantly verify that they have complied with the substantive procedures when they are taking out their general legislative work, including the function of impeaching a governor.
Yeah.
When they invest in this legal team, they will be able to vet and sieve the motions when they are going to be presented on the floor,
Yeah.
and also guide them
Yeah.
that in terms of our standing, for example, if it's Kericho County Assembly, our standing orders requires 1, 2, 3. The legal counsel will make sure that they comply, so that when the motion is now taken to the Senate, they are able to have the matter determined on substance as opposed to the preliminary procedural issues.
Yeah.
So that is the first take home,
Okay.
that investment. Now the law provides that once the county government, they get 2/3 of the MCS to vote in favor of the impeachment of the governor, then the Speaker of the County Assembly within 2 days has to communicate that decision to the Speaker of the Senate, 2 working days. So Once the Speaker of the Senate gets that communication, then he's also supposed to convene the Senate so that the Senate can now hear the impeachment motion. So it is done at two levels. So the preliminary issue that is normally raised, if you look at the impeachments that we have had, is based on the quorum of the MCS. Did they get the 2/3 of the MCS who voted? So this is something that just requires a measure of caution when they are doing the process, so that when they now come to the Senate, their grievance can now be addressed on the substantive issues. For example, was there mismanagement of public funds? If it was an issue of procurement, did they comply with the relevant procurement laws? So that is the biggest take home I want to give, so that we don't have the motions struck out on the basis of failure to comply with the basic elementary procedures.
Now, outside the law,
yes.
Look at
where the government has got a stake, for example, where that legislation is directly affecting the manifesto that they gave to the electorate. I understand that in such instances there may be lobbying on the part of either House, whether the National Assembly or the Senate, or even the County Assembly for their own legislations.
Yes.
But at the end of the day, the elected leader is supposed to reflect on the decision they want to make, and they make independent decision.
Yes.
But I agree with you that we have instances where most of our elected leaders at the various legislative assemblies, whether it's the County Assembly, the National Assembly, or the Senate, listen to the voices outside or voices in the executive. Indeed, it's true that in the impeachment of the Nairobi governor, when it was just at the stage when we were expecting it to take off, yes, the mover of the motion abandoned it. So the person who really has the responsibility to explain to the electorate why that did not happen are the people who actually initiated this motion.
What do you think happened? What do you think was the motion? Was the motion real, or it was just a political move to get a few clicks here and there?
To the extent that they updated the public that they already had more than 2/3 supporting them who have signed the motion, it means that they had a motion which we anticipated to be tabled so that the issues can be determined on merit.
Them failing to table it means what?
That means that they are not independent and they have let down the people who elected them, because the people who elected them expect them to act based on the best interests of the people who elected them. So it is really, it beats logic for somebody to come and tell the public that we have evidence that a certain governor has mismanaged public funds, has pilfered public resources. Then when we are waiting to hear this so that iwe funzo kwa wengine,
yes,
because there might be need for members of the public to have this matter prosecuted, so that if this governor is impeached and deterred from holding public office, then itakuwa funzo kwa wengine so that they don't do the same thing. So when a leader now comes to the public and says, we have abandoned it, without giving you the reasons why they have abandoned it, then it means they are not independent as they are required to be. Because when they are in that National Assembly, they are representing members of a certain ward. So they're supposed to listen to the people, because it's also the people who delegate political power to all elected leaders.
Yes.
So if you are elected as an MCA, you are supposed to constantly have a tete-a-tete with your constituents. And they're the people you're supposed to hear from. You can hear from your party leader on issues of party positions, but on issues of public resources which you are supposed to protect by checking on the expenditure of the county government, then your bosses, your primary boss, are the people who elected. You remember there's somebody who appeared before the NADCO committee, yeah, and you heard him saying the people, yeah, may exercise their power directly or through the newly elected.
May.
Yes, the people may. That guy actually had the spirit in the constitution. It was like the people who wrote the constitution, their spirits were talking to him. So it is those people who are supposed to tell the MCS to withdraw the motion. But ideally, if the grounds which have been presented, they're supposed to be taken for substantive trial, as opposed to people going to boardrooms and then they come and say, we have met with our supreme leaders and our supreme leaders have guided us to abandon this motion. That is very responsible of any elected leader, because the so-called supreme leaders who have advised you may not even be coming from the ward of you, the ward where you vote as an MCA. So it is imperative that every elected leader defers to the electorate who elected them. Some of the leaders that give them directions on how to vote one way or the other are not even the electorate. Maybe a leader who is giving you that directive lives here in Nairobi, but you are representing somebody who comes from Kajiado or another county.
Okay, now look at what happened with Sonko's impeachment. Look at what happened with...
From the scenario that you have given, I would say that there are two instances where, particularly for county governments, where the MCAs use impeachment. Sometimes they use it as a sword. Like, I know sometimes when the members of county assembly want to go for certain trips, so that they earn some allowances for trips, or when they want certain perks to be given to them, they use impeachment to then blackmail the governors, so that the governors can approve those expenditures that they aspire, or those allowances that they aspire to get.
Or even
and
contracts.
or if the people want some contracts to be awarded to their companies. But it still narrows down to what we were saying, that in whose interests are any elected leaders supposed to act? Because if the elected leader is blackmailing a governor to give them a contract, then it means he is considering himself and not the people who voted for him. Him or herself and not the people who voted.
What are the repercussions of such things when leaders go for handouts and didn't really stick to what is supposed to be done?
The repercussions are that the ordinary citizen suffers, because the money that is given in terms of kickbacks for payment of various services to county or national government ends up in the pockets of individuals, and the ordinary voter is not going to get that road that was supposed to be repaired. Remember, the county government is supposed to maintain certain roads. The money that was supposed to use to maram those roads, to put cabros on certain walkways, will end up in the pockets of individuals, and it is the electorate at the end of the day who is going to suffer. The various county governments, national governments, which face this kind of scenarios are also supposed to act in the interest of the electorate, because the moment they bow down to any pressure, whether it is from the executive, whether it's from businessmen, who are very few, maybe just want some pecuniary interest, then at the end of the day, the money is going to be directed to the wrong place. And the various developments that people voted hoping to get are not going to be achieved.
Okay.
Yes.
My last question. Look at how Parliament operates.
Thank you so much.
And what does it say about such kind of leadership?
Yes, thank you so much. I would like to first indicate that most Kenyans speak about the Senate and say that in the Senate there is very quality debate. They have substance. But I would like to draw your attention to the number. If you look at the number of senators, there are quite few. It is actually possible for all senators to speak on an issue. In the National Assembly, the number is so big. So you might find that, in the National Assembly, there are people who are prioritized to participate on an issue. There's the leader of majority, the leader of minority, the whips, and then again the people to speak are approved by the leaders from either side. So in the National Assembly, there might be very good debaters, there might be people who can actually contribute substantively, but maybe they're first-term MPs. You can see I saw one of the legislators telling someone in the National Assembly that you are a first-term, you need to listen when I'm speaking. So there should be room for debate. In the Senate, they have it. In the National Assembly, I think the time is constrained, but even if somebody does not get a chance to debate, but at the voting stage, they should vote objectively. They should vote by listening to the people. If you look at, for example, the finance Finance Bill 2024, you realize that it was very clear that the members of the National Assembly were not acting in the interest of the people. And it was so shameful of them when they now went to present, when they met the president, and the president now said it's not going to sign the finance bill as passed into law. And now some of them were clapping and cheering. They turned into a cheering squad. So it was a total embarrassment, and they should now be objective, because the president actually embarrassed them when he was able to now reject this finance bill that they passed by force, by fire, and now they were clapping for him. Yeah. So if you were to get each of those people who were clapping and you ask them, why were you cheering at the president and you were the one who passed this thing? So what has changed between that time? It actually demonstrated that these are people who listened to other forces other than the people who elected them. So that's the view that generally is there in the National Assembly. A few of them are good, but also sometimes you might see somebody debating so much, then at the end of the day, you see they abandon a certain position again. They say, if my party leader says left, left. If my party leader says jump 20 meters into the sky, they jump. So it again goes back to the issue. In politics, are you going to follow the views of the people who elected you, or you are going to follow the views of the party leader or the executive which is sponsoring various bills? Then there's also the issue of lobbying. I always see all politicians saying that I have gone to the government so that I can get development. But then allocation of funds is also done by the National Assembly. So maybe they need really to explain to us, what is this lobbying and how many can lobby? Because if it was lobbying, then we expect all the members of the National Assembly to line in front of State House, and each person now they book an appointment so that they all lobby. Because if you are saying we need to be strategic so that we lobby, then what about those who maybe the appointment diary for the president is full? What about those who are not going to get that appointment? Are they going to get development, or they're not going to get it? So there's so much in the theory, but also the political leadership need to be very responsible and give development without saying that so and so lobbied for this, let me give it to them.
Now back as we finalize.
At some instances, in the sense that when a governor differs with the ruling class for the day, then that governor or even a member of parliament, you will see that they are now being charged for some offenses that they allegedly committed. But well, there could also be merit in the charges that come, because, for example, if you are arrested by EACC, it will go for hearing. If there is evidence that you, for example, obtained some public funds illegally, then it will go for merit. It's only maybe the timing that makes so many people question whether they are objective or not. But to the extent that impeachment is about violation of the Constitution, and most instances about awarding of tenders, misuse of public funds, it is good that it goes for merit. And that's why my position has been that this is a bit of upholding notices of preliminary objection, because I see my learned colleagues, when they go to these impeachments, they raise preliminary objection, which most of them have been upheld. Sometimes it denies the Senate an opportunity to hear the case on merit. Though there was the Kericho case, the last impeachment from the Kericho County government, where at least there was some element of merit-based analysis of the case before the senators voted. So in as much as there's the issue of preliminary objections, I don't want to say it's a technicality, because it's also a legal issue for somebody to raise a preliminary objection. The preliminary objection should be determined together with the evidence that had been tabled. I believe the senators can withhold their voting on this preliminary objection so that we first hear what are the charges, so that the lawyers are able to cross-examine and find out whether there is even merit. Then, at the point of determination, they can put that issue of the preliminary objection as one of the items for the vote, so that at least there is also, we have exposed to the public that this is why we brought this person here. That will also help to remove the perception that this could have just been a political witch hunt. So I would encourage our distinguished members of the Senate and even National Assembly, where they are able to impeach, like the one they did for the former deputy president, to at least give some room for merit analysis of the issues for the impeachment. The issue of preliminary objection, whether there was quorum or not, can also be put as a voting item at the tail end when we are determining each count. That would help Kenyans to get some level of accountability. Because at least, if you're a governor and you are exposed, somebody saying you appointed your wife, your wife's brother, you gave them this tender, you used this, whether the preliminary objection is upheld at the end, but this person will have also been exposed, and therefore there will be some degree of shame which can prohibit him or her from continuing to pilfer or to mismanage public funds. Yes.
Thank you for making time for us.